The other important provision is setting standards and working on these standards. Recall the discussions that we had in the lecture on Environment Protection Act. The same provisions are here, and you know very well, center makes the standards, the states would implement that. There are certain conditions for implementation of that, and one such condition is that you can come up with a stricter standard at the state level and enforce it, or you can just adopt the standards laid down by the center and operationalize it through your rules here, framed from time to time by you. After the making of the Environment Protection Act, an amendment was made to Air Act, and that is to extend air pollution to noise pollution as well. This is a wonderful provision. And based upon this, rules were made under the Environment Protection Act in the year 2000, noise pollution regulation and control of rules, 14th February 2000. What does it contain? There are two types of standards that are prescribed. One is what is called as ambient air quality standards. These are the standards prescribed for industries, commercial areas, and residential areas. They are what are called as silence zones. This is where exactly this is operative. And the second one is emission limits for designated types. The decibel level should be of a particular level. In case of machineries, what is the decibel level? In case of appliances, in case of firecrackers, restrictions on use of loudspeakers and public address systems, all these are made in fairly greater detail in the rules that are made under this, and everyone need have to conform to it. It's a very interesting law, and if you examine this law, it actually is an enabling law. And by just reading this law, you will not know how to implement this law. Actually, if you look at the law concerning nuisance I mentioned earlier, it is the district magistrate who has the final decision-making power with regard to that. And it is the police officers who have the duty to deal with the issues of noise pollution in various public places. And so this law has to be read with the Police Act, the Indian Penal Code, Motor Vehicles Act, local self-government laws, and mere reading of the amendment to the Air Act and extension of the application of this law is not possible unless and until you put all of them together, and thereby you have an extended definition of air pollution. The long and short of it is, the real enforcer of the law concerning noise pollution is the general administration, the police authorities, and the district magistrate, whom you call as the executive magistrate. But the technical support in determining what amounts to noise pollution comes from the State Pollution Control Board under the power that has been vested in them. So supposing the police authorities do not act, the Pollution Control Board can instruct the police authorities, look, the particular limit that has been prescribed for such and such an entity has been exceeded, and it is affecting the public peace, and so you shall act on that. It can give instructions to them. That means the Pollution Control Board cannot directly act, but it will act through this particular authority, and if this particular authority does not comply with what the Pollution Control Board instructs, then the Pollution Control Board can proceed against them and take action against them for having violated this law. So look at the function of the Pollution Control Board. It can act against an industry, a private entity, it can act against an individual, it can act anyone who is violating this law, it can act against a governmental agency created under any law when noise pollution issues are involved. A very broad spectrum of activities, a very broad spectrum of authorities who are brought under the pale and purview of the pollution control laws here. There are very interesting cases here on this, and it's very necessary that we take a peep into some of these cases, because the evolution of the law concerning noise pollution, the rules I had mentioned, came into existence only in the year 2000. Although in 1987, air pollution also included noise pollution, but the details of setting standards, prescribing the decibel levels, and the determination of exceeding standards were not worked out. And so, by and large, the police and other authorities were relying upon their respective laws, Motor Vehicles Act, the Police Act, whatever they prescribed, and they used to act on that. And even the pollution control boards, their hands were tied. They did not know what to do. Anyway, the other agencies acting, we did not do anything about it. They were keeping quiet. But in the year 2000, these rules came, which made it very clear the role, responsibility, and function of every authority as to how they should act whenever there is noise pollution, and what kind of measures that they have to take, and how to control that to maintain the public peace and public order. This happened mainly because of a number of decisions given by the higher judiciary, which took note of this particular problem not being addressed very clearly by administration, and so it gave directions to the administration, it gave directions to the government: enact those laws, come up with details of procedures, please take action, because the public health and public well-being and public peace is at stake. The quality of life is getting affected. How did that happen? Two, three cases. Let me start with the case of YTOK. He's a doctor by profession, and a doctor noticed that this is in state of Maharashtra. Several activities that was going around this clinic, like the vehicular movements, the industrial activity, was providing so much of noise as to make it unbearable for the people. And nobody was really caring about taking action on that. And so he went and submitted before the High Court there a writ petition that high noise levels, as a doctor I have noticed, is impacting on human health. It is a public interest, and I'm bringing in this public interest litigation. I don't know about the law, but there has to be some kind of an action taken. Governmental agencies are not really doing anything. Kindly help. And the Chief Justice, there, Justice Sujata Manohar, laid on wonderful orders, and these orders are essentially based on an expert committee that was constituted, which came with its findings, and those recommendations were actually made part of the judgment here. And all that you find here is that in case of hospitals, what you should do. In case of those silent zones where schools and college and educational institutions are there, wherever there is residential areas are there, when there is a religious function that's going on, what kind of safeguard measures that should be there. All these were part of the recommendation of this expert committee, and that became part of the law later. And when once this was done, and the law also came into force, when no satisfactory action was taken, a second petition was made by him, and rules for loudspeaker were made by the state government. And they found that these rules that you made were contrary to the national air ambient quality levels, and this is actually violated during Navratri and Ganesha festivals, and whatever prescription as to the use of loudspeakers beyond 11:30 are not followed. The High Court observed in this particular judgment of it that this is a very sorry state of affairs. Some 45 years back, there's a Supreme Court judgment which makes it a very clear distinction between people observing certain kinds of faith, religious faith and belief, and religious practices, We are not going to question that, but what the state should protect under the constitution is the religious faith and belief. The good of the state as a whole would take precedence over and overrides the practices related to religious faith. Such practices which run counter to public order, public morality, public health, or policy of social welfare is not something that should be tolerated by the state, and high level of noise pollution on account of a particular religious practice is intolerable. The state shall not protect that because it affects public interest. Religious faith, we will respect that. Religious belief, you shall not question, but religious practice of this kind, which is pernicious and affecting public health, should be stopped. And state should take action on that. You have laws on that. Please implement those laws. That's what the court instructed the government. We have another case coming from Kerala, very similar case. And here, the argument was that in a public place, here was a political meeting, and in the public place, a political leader was making a big speech, very loud noise. The neighboring people were affected by that. They brought in an PIL. Look, you have these regulations, and there are certain limitations for loudspeakers use beyond 50 meters. It should not really spill into the public place and affect the well-being of the people. That's what has been prescribed, and still nothing being observed. Kindly help. That is the case of P.A. Jacob versus Superintendent of Police, and this is about certain religious practices. This is about certain political meetings. This is about certain celebrations that were taking place in public place with loud noise. And there was a very interesting observation made by Justice Shankaran. He said that when we talk of fundamental right to speech and expression, which is a fundamental right that everyone has a right to express oneself, it does not mean that you have a right to use loudspeakers. If you want to use loudspeakers, follow the rules prescribed therein. And people beyond a particular limit of the use of these loudspeakers have also a similar right to be left alone. They should be free. They should have freedom from oral aggression. Unlimited oral aggression on unwilling listeners is like subjugating right to life to such aggression. And so reasonable use of loudspeakers should be permitted. And even if certain practices adopted by the church orthodoxy for which you make a public speech, fine, provided it is not going to really affect public health, public morality, and right to be left alone. Similarly, with regard to the use of air horns in buses and public transport system, there is another case decided by the Calcutta High Court. I have mentioned that case. Please refer to that. Limitations were imposed on that. And this is yet another case decided by the Calcutta High Court, which says the state restricts the use of loudspeakers between 9 p.m. and 7 a.m. This is in Calcutta or Kolkata now. And the claim of this particular religious faith that every day, a number of times, there is an azan where there is a call for the believers to assemble and then pray. And azan is an integral aspect of Islam. It is required to be called 5 times a day, and it can reach the believers of Islam only through loudspeakers, and it should be permitted. And that was actually called into question in the Maulana Mufti Syed Barkati versus State of West Bengal as early as in 1999. We are referring to the case in 2020 because you see the violations occurring even now. What did the court say here? This is exactly what the court said. You have a right to religion, a fundamental right. You have a freedom of speech, which is a fundamental right. But your argument cannot be upholded because the using of the loudspeakers is a technological development and it is not part of Islam. You follow Islamic practices, but Islam does not promote use of loudspeakers. How you reach your believers, it is your lookout. But in your enthusiasm in reaching your believers or the believers of your faith, it should not in any way affect similar such right not to believe your faith by so many other people. Their right would be infringed upon. Your right ends when the right of others begin, and Islam does not promote use of loudspeakers. I don't think the court of law can be much more clearer than this, and noise pollution laws are very robust laws, but the only problem with regard to noise pollution control is it requires very many authorities to deal with this problem situation, and the pollution control board is supposed to provide the technical support for ensuring these standards are maintained and observed. The police and the general administration did have to act every time when there is a complaint. But there is no question of using a discretion beyond the limit that has been prescribed under this law. But most of the time it is not being observed. And if you ask about the legal prescription, if you ask about judicial clarification, they are very clearly there. The only need is to implement. There is a need for implementation for which you don't need a political will. You need an administrative will to ensure that every law made under the law of the land should be implemented and others need to comply. And if there is any deviation, to take action without any leave, let, license or concession. More concessions you give, you are actually acting arbitrarily. That's the sum and substance of this. Motor vehicle pollution is another area, a vastly unregulated activity for a pretty long period of time. And you know, of the pollution that is caused in urban areas especially, more than 60% of air pollution is caused by motor vehicles. And unfortunately, the pollution control regime did not really provide for standards of motor vehicle or pollution for a pretty long period of time. The ERA came into existence in 1981. There were no regulations. And in 1984, the Central Pollution Control Board constituted a committee to do a few research work and then come up with a recommendation, and some kind of a general standard was laid down, but they were not very satisfactory. They were not very satisfactory for the simple reason that the standards that were prescribed, following upon a bit of a consultation and those exercises that were carried out by Central Pollution Control Board, was actually a set of standards prescribed which had only what has been suggested by the motor vehicle automobile industry. And an industry would always come up with those terms and conditions which would actually satisfy and ensure them to do the ease of business, not bothering about whether it conforms to some standards or anything like that scientifically arrived at. And everything worked well according to both the government people and the industry, but people were finding it very difficult that this kind of a concession that has been given, a standard which was just there for namesake, which did not really satisfy the public good or for that matter follow any scientific requirement, became a subject matter of a major Supreme Court case that was decided by the Supreme Court over a period of time. For nearly 30 years, this was actually the concern of the Supreme Court. It made its appearance for the first time in 1991, right from 1980s when MC Mehta brought in this action. And what the Supreme Court did, a number of expert committees were constituted, and each of those times the Supreme Court came up with a number of orders asking about the administration to act on it. There were delays in acting on that. There was poor response from the industry. There was a lot of political gimmick about that, and most of it is business as usual kind of a thing. Each in their own way contributing to the confusion of vehicular pollution. And Supreme Court said enough is enough. And it started coming up with a number of expert committees coming up with a set of recommendations based upon which it started prescribing norms and conditions for compliance by everyone. It was an instruction to the policymaker, it was an instruction to the lawmaker, it was an instruction to the industry to ensure that people could breathe easy going into the streets. They came up with emission standards, they came up with engine designs, they came up with fuel quality, they came up with norms for retiring and phasing out old vehicles, etc. One may ask the question, why did the court come up with policy, legal and administrative reformative measures? For the obvious reason that the administration did not act, the lawmaker did not do anything, and those expert bodies like the Pollution Control Board, as I had mentioned earlier, were only following whatever that the automobile industry wanted. It's almost like the one who is accused coming up with framing of rules, and that's being implemented by the enforcement agency, which was a highly unsatisfactory state of affairs. And so the court had to come up with that. It primarily adopted the standards adopted in Europe, the Euro 3 and Euro 4 standards. And these standards were later read into the rules prescribed under the Environment Protection Act, and they came as Bharat 3 and Bharat 4 standards, and these were evolved mainly because of the intervention of the court of law with regard to vehicular pollution. The other function that's being made available for the pollution control boards is the power to initiate legal proceedings. You know that, as has been mentioned earlier under the Environment Protection Act and also under these two laws, courts of law have no jurisdiction to deal with pollution control issues at the district court level. High Court and Supreme Court, as a public interest litigation, can take it up, but the lower courts have no jurisdiction. There is a clear bar on jurisdiction. But court can come into play only under two circumstances. One is when the Pollution Control Board itself makes an application, and second, when an ordinary member of the public comes up with a case before that. We have already discussed that in the Environment Protection Act. The same is the law made here. And just to mention, to recall whatever that has been discussed, the Pollution Control Board can make an application to the court either in apprehension of a polluting activity or when actually a pollution has occurred because of the conduct of certain individuals or an industry or anybody, and the court may pass any order deemed necessary, including orders for restraint or removal. This is called as an injunctive order. Upon non-compliance, the board is authorized to implement its directions and recover the costs. That's a very important power. But as a matter of fact, I have referred to a few cases. It's very simple. The reason why I'm not going into the details, this is like something that's a reading and a homework that the student will have to do. Read these cases and you will know as to what exactly is the import of this law. To put it in a nutshell, there cannot be a claim by anyone that I can carry on any trade or a profession or an industrial activity, which is a fundamental right of me. That can be done only when it does not violate anybody else's right to life of everybody. is very precious, and it should not come in the way of right to life. And second, it should not violate any of the provisions of Environment Protection Act or the pollution control regime that we have discussed so far. And conforming to them is like observing legal prescriptions, which is a reasonable restraint on your fundamental right to carry on any trade or calling, and so you cannot challenge the action of the authorities as being violative of fundamental right, and it is not violation of the Constitution. In fact, it is very much within the reasonable restrictions provided under this law. To put it in very simple terms, this is a very simple power that is vested in the pollution control boards of applying it to the court for action. This is a power, all right, but far more serious power that is available, far more effective power that is available for the pollution control board under section 33A and 31A of Water Act and Air Act respectively, as has been discussed a little while back, of actually issuing orders. You need not have to go to court, get an order from the court and act on it. You as a quasi-judicial body, when once you have noticed there is a clear violation of the law, like a court, you can decide. And it is the duty of the one against whom the order is issued, he should act. So given that kind of a power, that of a court, why should you apply to a court? There are several arguments that we have to retain that particular provision. And there is also an argument that there is no need to retain that provision. The argument that you don't have to retain that provision of applying to the court because you have a higher power of you yourself issuing an order, just like that of a court of law. And so that rule is unnecessary. But the argument on the other side is that those rules are also necessary because many a time, if you draw the attention of the court of law, it will add a little bit more gravitas, strength to the action that you initiate. And so the court action and this quasi-judicial power exercised by this authority would have a far more deeper impact. And so we should retain both the provisions. As far as the decision of the Pollution Control Board is concerned, there is only one provision which can be appealed against, and that is within 30 days of the order against the consent order. All other orders of the board are unappealable because that's like the order of a court of law. But within 30 days, the appeal has to be made. Appeal to whom? Appeal has to be made to an appellate authority. Normally, in every state, the state government appoints an appellate authority to hear grievances and disputes that anybody would have against the Pollution Control Board. And to that appellate authority, the grievance need have to be submitted and it will decide. And wherever such an appellate body is there, and this appeal can be sought, the government cannot intervene. But when there is other provision, some decision is taken by the board, and there is no scope for an appeal other than the consent order, standard not being conformed or anything like that. On that, there is a power of revision vested in the state government, which I mentioned earlier. The state government can revise the order of the Pollution Control Board if there is no appeal sought or an appellate authority is there and no appeal has been made. The decision of the Pollution Control Board in such situations becomes final and binding. So, in effect, what we are referring to a very robust law that gets reinforced with the making of the Environment Protection Act and the rules thereunder. From time to time, the Pollution Control Board is armed with more powers, more functions to discharge. And if there is still a problem of pollution and the problem is getting exacerbated over a period of time, now you know that the problem does not lie in what is there in the letter and spirit of the law. enough power has been vested, enough functions are being given, enough rationale for actions are given, even judicial powers are vested in the authority, and if results are not to be seen, I think there must be some problem with regard to compliance. There must be some problem with regard to the way and the manner of implementing these regulations. There are provisions with regard to environmental criminal liability of corporate managers and heads of departments. It is the same as what has been there under the Environment Protection Act that was discussed in the lecture on Environment Protection Act. This comes to a close. The detailed discussion on the entire law concerning Environment Protection Act, the law for protecting the environment, and the law in dealing with pollution control, the general law concerning environmental protection, and a very specialized law with specialists enforcing that, the pollution control regime comprising of the Water Prevention and Control of Pollution Act and Environment Protect and Air Prevention and Control of Pollution Act, all enforced by the Pollution Control Board, further strengthened by the additional tools and techniques that are provided under the Environment Protection Act. With this, we have laid down the ground for taking it to the next level of our inquiry, that having discussed about the pollution control law, what is the law and its working with regard to certain sectors of pollution and waste management, on environmental protection and economic development, on taking care of some sensitive areas and their management. What does the law say and how it is being worked on those specialized areas where life and life forms needed to be conserved and protected? And that becomes a subject matter of our inquiry in the subsequent modules that we are going to get into, and that will be the discussion that we will be engaged in.